Previously on Con Law and Order.
It is our duty to fight for our planet. It is our duty to win.
In 2015, a group of 21 young plaintiffs filed a lawsuit against the U.S. government in the District Court for the District of Oregon. Their complaint alleged that the government had violated their constitutional rights to life, liberty, and property because of affirmative actions taken by the government that caused climate change. The government argued that the plaintiffs did not have standing to sue, stating that the plaintiffs did not have an injury in fact. The injury was not caused by the government, and even if a court did rule in favor of the plaintiffs, their injury could not be redressed.
Settle down, counselor. You're out of order.
I'm not out of order. You're out of order.
U.S. District Judge Ann Aiken disagreed, stating that, by exercising her reasoned judgment, she had no doubt that the right to a climate system capable of sustaining human life is fundamental to a free and ordered society. The government has appealed the finding of standing with oral argument to take place on June 3, 2019. On June 3rd, the young plaintiffs will again bring the fight to the United States government. They will have to prove that they can meet the constitutional requirements of standing, injury, causation, and redressability. If they cannot meet those requirements, the case must be dismissed.
In the constitutional justice system, the people are represented by two separate yet equally important groups: the plaintiff attorneys who bring the suit and the attorneys who defend against it. These are their stories.
All rise for the Honorable Judge Judy.
Good morning, counselors. You may be seated. All right, counsel, today we are here to hear arguments on plaintiff's standing or lack thereof to sue the United States government for climate change. Counsel for appellants, you may begin.
Thank you, Your Honor. My name is Luton Plunder from Greeley, Plunder, and Newcomb, and I am arguing on behalf of the U.S. government. We are not here to debate the merits of the idea of so-called global warming. We are here to argue that the plaintiffs do not have standing to sue. This is a generalized grievance not capable of being settled in U.S. courts. All of us experienced constitutional lawyers know too well the Supreme Court has held that there is a specific test for standing, from Defenders of Wildlife versus Lujan. Plaintiff must allege a concrete and particularized injury that is fairly traceable to the defendant and is redressable by this court. Despite their melodramatic briefs, the plaintiffs have not identified a specific or concrete injury, alleging only events that may or may not come to pass. In multiple federal lawsuits, including Wild Earth Guardians versus Salazar, Amigos Bravos versus U.S. Bureau of Land Management, and Center for Biological Diversity versus U.S. Department of the Interior, federal courts have found that alleged injuries due to climate change do not suffice for purposes of standing. There is nothing new here.
Your Honor, I have prepared a statement to read here.
Counsel, you're not a witness. You're not testifying. You don't need a statement.
Okay, well, I'd like to give one anyway. Just, excuse me, sorry. Your Honor, I am August Greeley Jr. from Greeley, Plunder, and Newcomb, and I just wanted to state for the record that I am also contributing, and I co-sign everything my co-counselor just said. I also think it's important that you know that I am really excited to be here and have been looking forward to it ever since that and let the record show that I said thanks, Daddy.
Watch yourself, Mr. Greeley. Ms. Plunder, does the government deny that climate change exists?
Your Honor, even if we admitted that by being smoking hot, I increase global temperatures, it wouldn't matter. The plaintiffs have still not demonstrated that we are the root of their climate woes. In Massachusetts versus EPA, the state challenged one specific EPA regulation as essentially contributing minimally to global warming by not preventing a certain percentage of greenhouse gases from entering the atmosphere. Here, there is no such specific challenge. Much like in Washington Environmental Council v. Ballin, the causal chain is too tenuous here because tons of people contribute to global climate change. Plaintiffs must also at least say that there's a substantial likelihood that the supposed future injuries will occur, and that they will be addressed by a court decision according to Allen v. Wright. Here, it looks like Alexandria Ocasio-Cortez will personally make sure that global warming stops, so none of the injuries they allege will occur. So I'm not sure why we're even standing here today. Which reminds me, plaintiffs have no standing. The government rests its case.
And Your Honor, I just wanted to add, and I can't believe no one's mentioned this yet, but concerning redressability, the tree huggers, they're not even redressed properly. I have had a suit since I was 3 years old, okay? What's their excuse? I don't get it.
Thank you, counsel. Counsel for appellees, you may begin.
Thank you, Your Honor. My name is Moonlight Sage, representing the children of the future, and my co-counsel should be on his way.
Leaf green, though. Sorry I'm late, Your Honor. I was just riding my bike here, saving the planet.
Your Honor, concerning the first prong of the test, the injury in fact. As well stated in Friends of the Earth, a decision from 2000, when we are dealing with an environmental case, a plaintiff can not demonstrate injury in fact by alleging injury to the environment itself. There must be an allegation that the challenged conduct is harming or imminently will harm the plaintiff. So a plaintiff may meet the injury in fact requirement by alleging that the challenged activity impairs his or her economic interest or aesthetic and environmental well-being. And that was well stated in the Bellon decision from 2013.
Here, each plaintiff adequately alleges injury in fact. A few examples, if I may. Plaintiff Juliana alleges algae blooms harm the water she drinks, and low water levels caused by drought kill the wild salmon she eats. Guess that means no more sushi. Plaintiff Rosque Martinez alleges increased wildfires and extreme flooding jeopardizes personal safety. Plaintiff Loznak alleges record-setting temperatures harm the health of the hazelnut orchard on his family farm, an important source of revenue and food for him and his family. Plaintiff Zealand alleges he has been unable to ski during the winter as a result of a decreased snowpack. Guess that means no more trips to Aspen. Plaintiff Sahara alleges hot and dry conditions caused by forest fires aggravate her asthma. But I guess breathing isn't important to some people. The government argues that these injuries are not particular to the plaintiffs because they are caused by climate change, which broadly affects the entire planet and all the people in it in some way. According to the government, this renders plaintiffs' injuries non-justiciable, generalized grievances.
This speech is causing me to fall asleep.
Honnêtement, franchement, votre honneur, I'm going to lose it. I need to speak French or something. I don't understand. L'interprétation du gouvernement est totalement erronée. Le fait que les victimes soient multiples et aient subi ou subiront le même dommage, enfin, on n'en a rien à faire, honnêtement. Les décisions Jewell versus NSA, vous pouvez voir, c'est dans le dossier en 2011, ainsi que Massachusetts versus EPA en 2007, c'est aussi dans notre dossier. Ces décisions sont très claires à ce sujet. Son ras-le-bol de ce comportement, ça commence franchement à bien faire. Peu importe combien de personnes ont subi le dommage, tant que la partie qui agit en justice peut prouver un dommage concret et particulier. Et en l'occurrence, c'est ce que font tous les plaignants ici dans ce dossier.
Objection, Your Honor. The folks over there are saying things that I don't like, and I don't agree with them, and I am formally demanding that they stop.
Counselor, we've been through this. Sit down.
Yes.
The second requirement of standing is causation. As demonstrated by Defenders of Wildlife v. Lujan, a plaintiff must show the injury alleged is fairly traceable to the challenged action of the defendant and not the result of the independent action of some third party not before the court. Although a defendant's action need not be the sole source of injury to support standing, the line of causation between the defendant's action and the plaintiff's harm must be more than attenuated. This is demonstrated through Native Village of Cavallina v. ExxonMobil Corp. However, a causal chain does not fail simply because it has several links, provided those links are not hypothetical or tenuous and remain plausible.
Your Honor, concerning the third prong of the test, concerning the redressability issue. So as well stated by Bellon and Lujan, the redressability element of standing does not require certainty, but only a likelihood that the injury will be redressed by a favorable judicial decision. And additionally, it's sufficient to show that the requested remedy would slow down or reduce the harm. And that was well stated in Massachusetts versus EPA and also in Larson versus Valent. So here in our case, the plaintiffs are asking the court to order the defendants to prepare and implement an enforceable national plan to phase out fossil fuel emissions and draw down excess atmospheric CO2. So the injunctive relief that the plaintiffs are requesting meets the redressability standard. First, and it's all in our pleadings and in all our exhibits, the defendants have control over a quarter of the planet's greenhouse gas emissions, and a reduction in those emissions would reduce drastically the atmospheric CO2 and slow down climate change. Therefore, the third prong of the test is met.
Thank you, counselors. You have both given me much to deliberate over. I will retire to my chambers to discuss with my law clerk, and we will reconvene at 4 p.m. Dismissed. All right, counsel. I've made a decision on the issue of standing in this case, and the verdict is...
You'll pay for this, Captain Planet!